I've started, so let me do that again. I may have failed to press the recording button earlier. So welcome everyone to tonight's session on week 3 about merit review and administrative tribunals. I'm your unit coordinator, Manjo Oison, and I thank you for joining again tonight's tutorial. So tonight, we will talk more about merit review and administrative tribunals. And as we talk about the process of merit review and administrative tribunals, particularly the Administrative Appeals Tribunal, which was created by the Administrative Appeals Tribunal Act of 1975 Commonwealth, we will try to draw a distinction between merit review versus judicial review and the AAT as opposed to the review process that is undertaken by the courts. So I'm glad we have a fourth person to join us, Josh. So thanks for joining us. So, and Millie as well. Hello. So there are 5 students. I'm glad, I'm always happy when there are more students joining the tutorial. What I'm gonna do in the meantime is to mute everyone. And if you feel like, you wanted to say something, feel free to raise your hand or just unmute yourself. But in the meantime, just to avoid any background noise that may disrupt the learning process of a lot of other participants, I've decided to mute everyone. Did anyone wish to say anything in the meantime before I continue? None? Okay. So a lot of you, when you become lawyers, and even now, even as non-lawyers, you likely, when we went through the week 1 tutorial, I had asked you if you ever had any opportunity to deal with administrative agencies and whether or not there were times when decisions were made by certain administrative agencies which you felt violated some of your rights, and you wanted somehow to have a review of those decisions made. And so therefore, what this tells us, or what this suggests, is that the idea about administrative review is actually something that is quite common, not just to lawyers, but to a lot of other people, because what we need to remember is that the executive or the administration, in fact, makes decisions almost every day that have a strong impact on its citizens. Their decisions have a major effect on us. The decisions could be, in relation to settling benefits. It could be in relation to Medicare. For some, it could be in relation to immigration, especially for those who may consider bringing in somebody as a spouse or as a partner from abroad. Or for some, it may be asking about, what's going on with the boat refugees and why do they continue to be, in a sense, incarcerated in some of these detention centers. It could be questions about, in the event for some of you who may have had a very unfortunate experience of having to go through a breakup and there are children involved, there might be problems about child support, and you have the child support agency making assessments, and sometimes we feel like the assessments are unreasonable. And so therefore, in these instances, you begin to wonder, if you are aggrieved by an administrative decision, what are your remedies and where can you go to? Can you only go to courts? And we know that if you have to go to courts, you need to have some background in law, and judges often don't really welcome self-represented litigants because they're, self-represented litigants, because of their unfamiliarity with the law and court processes, can take up much time with the court, and judges don't want to bother with that. But if you go through a review process in an administrative tribunal such as the AAT, you have the benefit of a process that is informal and non-technical. So the usual rules of evidence that apply in courts are not observed in administrative tribunals generally. And so therefore, there is an advantage to knowing about the merit review process that is happening in administrative tribunals. And so tonight, we're going to focus our attention on merit review and administrative tribunals. And after the session, you should be able to discuss the essential characteristics of merit review, the jurisdiction of the AAT, and scope of AAT merits review. And as I pointed out, there will be 3 other things that will happen tonight. One is I will try to compare and contrast what goes on, compare merits review versus judicial review, how it is like for the AAT as opposed to what happens in the federal system, in the federal judicial system. At the same time, I will draw your attention to quiz 2, because quiz 2 pertains to the AAT, and so we're going to have a look at the quiz. I will not answer the quiz question itself, but I will draw your attention to some of the key principles so that at the end of the session you should be in a position to come up with the correct answer to that quiz. And thirdly, before we proceed any further, what I'd like to point out is that when we speak of administrative review, and particularly when you talk about the review by administrative tribunals, because we often talk in terms of judicial review as opposed to merit review or review by administrative tribunals. What we need to remember is that there is such a thing as an internal review process. So in other words, once a decision is made by a delegate of a decision maker, so it could be a low-level employee of Centrelink or Medicare or one of those government agencies, and you are unhappy with the decision, it shouldn't have to be the case that because you feel like you're aggrieved by the decision that you need to go either to the courts or to apply to the AAT. What often should happen is for you to consider the possibility that you will seek an internal review. So an internal review can consist of 2 parts. You actually just talk to the original decision maker, the delegate, the low-level employee making the decision, or if that doesn't work, then you elevate a review of the decision to the manager of that particular agency. So that's an internal review. And I've had instances myself when I've actually had to deal with, with Centrelink, with child support agency. And when I flagged to them my desire that if I was unhappy with the decision of that employee, I was going to seek an internal review of that decision. That alone, I felt, made the decision maker more cautious, because I would think they don't want their decisions to have to be reviewed. And I think what often happens is that when decisions are made by the executive, and I'm talking about the delegates, or those who are actually making the decisions in the front lines, what often happens is that there is a tendency on the part of most people to just accept the decision. And they don't bother seeking a review. Either one, because they don't really know that they have the right for the decision to be reviewed, or two, they don't know that the decision could actually be impugned because the decision is probably incorrect, or there could have been a better way for the decision to be arrived at, or three, they probably felt that it would be too cumbersome to have to go through the process of having a review. But at least with a knowledge of how the review process works in administrative agencies, it gives you a major edge already in dealing with administrative agencies. So from the level of your own, of your own individual experience, you will realize the value of knowing about administrative law. And eventually, when you become lawyers as well, you'll be dealing with clients who will most likely come to you because they have questions about decisions made by the executive. So I'm just flagging to the why it is so important to talk about administrative law. So having had that introductory discussion, let's look at quiz 2. What we're going to do is to just go through the question, and then I will not provide the answer, but I will highlight for you some of the key principles, which will then go through in the tutorial. Can I get someone to volunteer just to read the quiz for us? Can somebody do that?
Yeah, I can.
Millie, thank you.
The Australian Minister for Immigration and Border Protection, the Minister, terminated the employment of Visa Officer Josh Goodwin after the latter was found, after an internal disciplinary hearing, to have committed a gross error, both in law and in fact, in applying the Migration Act 1958 Commonwealth to the application for an Australian permanent residence visa of Omar Usawi. Usawi had committed domestic terrorism in Australia. The Minister used his non-statutory executive power in terminating the employment of Goodwin. Goodwin has approached you, a solicitor, for legal advice. He wants to apply for a review of the administrative decision terminating his employment. Which answer is the most correct?
Can I
He cannot. Do you want me to keep reading?
Yeah, please go on.
Yep. He cannot apply for a merit review with the Administrative Appeals Tribunal because the decision of the minister was based on the exercise of non-statutory executive power. He cannot apply for a merit review with the Administrative Appeals Tribunal because the Administrative Appeals Tribunal has no jurisdiction to examine legal errors in administrative decisions. He can apply for judicial review under the Administrative Decisions Act 1977 Commonwealth because the termination was made by the minister on the basis of the exercise of non-statutory executive power. He can apply for merit review with the AAT because the decision of the minister was based on an enactment, or all of the answers are wrong.
Okay, thank you, Billy. I should have been 1975. I didn't notice that. Okay, so that's the AAT. Oh, sorry. Hang on. Oh, okay. I was correct. I was actually looking at judicial review. I was thinking it was the AAT. Okay, very good. So the third answer was actually about the Administrative Decisions Judicial Review Act of 1977 Commonwealth, which pertained to judicial review. I was thinking of the AAT Act of 1975. Okay, so what we need to point out here is that the decision of the minister is actually based on the exercise of non-statutory executive power. So let's just highlight that, okay? So keep in mind that the decision of the minister was not based on a statute, but based on the exercise of his non-statutory executive power. And, you know, just as a reminder, because I think all of you were here last time, in relation to the executive power, the power of the executive can rest, one, on the Constitution, meaning particularly Section 61 of the Australian Commonwealth Constitution. It could rest on statute. In other words, the legislature may in fact empower the executive through primary legislation to, you know, exercise certain powers. So that will be the exercise of statutory executive power. Or it could be that there are certain powers known as implied or inherent powers of the executive, which we sometimes call prerogative powers, because what we need to remember is that countries or jurisdictions such as the UK or New Zealand, they don't have any constitution. So you cannot say that because there is no constitution, therefore they don't have an executive power. And what if their parliament does not provide any power to the executive? Does it mean therefore that the executive or the prime minister and his cabinet do not have any executive power? And the answer is no, because in any government, for the government to be able to operate, it needs a functioning executive. And therefore, it is recognized that in any framework of government, there has to be an executive with inherent powers or prerogative powers. And especially if you look at the history of the UK, we know that the king or the monarch of the UK always had executive powers, and it never relied on any constitution. It never relied on the parliament. In fact, for a long time, because of the notion of the absolute monarchy, the king was superior to parliament until they had that battle in the 1350s, what is known as the Battle of the Orange, where the UK parliament was able to assert its authority even over the king. So that in the UK now, and which is similar to the one in New Zealand, we have what is known as parliamentary supremacy, so that it is recognized that parliament is supreme. And in those jurisdictions, courts do not have a power to declare as unconstitutional or invalid a law that is passed by their parliament. So having said that, I need to flag your attention to the fact that in the particular facts, the decision of the minister was based on the exercise of non-statutory executive power. At the same time, there is a curious answer here because it says that the AAT has no jurisdiction to examine legal errors in administrative decisions. We will know if that is in fact a correct statement or not. Because we remember that when we talk about judicial review, the function of judicial review is limited to examining the legality of administrative decisions. It cannot examine the merits of administrative decisions. In other words, when you have a judicial review, and I'm talking about, remember, we're talking about the federal level of government, not the states. And I cannot go into that again because we don't have the time, but I discussed it last week. So at the federal level, we said that when you have federal judicial review, courts can only examine the legality of administrative decisions. They cannot examine the merits or the factual correctness of administrative decisions, and they cannot certainly examine whether or not it was correct or preferable for the administrative decision maker to exercise his discretion, his or her discretion in a particular way. So the focus of judicial review is really looking at the legality of administrative decisions. Now, if that is the case, does it therefore follow that the power of the AAT is limited only to an examination of the merits of administrative decisions? And when we speak of merits, does it mean that it only has to refer to the factual correctness or the exercise of discretion, so that the AAT has no power to examine legal errors? That is something which we will learn tonight in greater detail, and which has been covered in the textbook, and which is also in the lecture notes. So bear that in mind, because if that answer is correct, if that statement is correct, that the AAT has no jurisdiction to examine legal errors in administrative decisions, so you have a particular answer there. So we're going to have a look at that. And then, okay, I'll not go through answer 3, because I already flagged it, that the minister uses non-statutory executive power. And then he can apply, the fourth answer was he can apply for merit review with the AAT because the decision of the minister was based on an enactment. Oh, okay, sorry. That was clear. It was not based on an enactment. Rather, let me go back to answer 3. He can apply for judicial review under the Administrative Decisions Judicial Review Act 1977 because the termination was made by the minister on the basis of the exercise of non-statutory executive power. Okay, so what this tells us is that, just as by way of review, when it comes to judicial review on the basis of the ADJR Act of 1977, the requirement there is that the administrative decision must have been based on an enactment. So let's clarify that. Okay, so if you're trying to apply for the judicial review on the basis or under the ADJR Act, the requirement is that the administrative decision must have been based on an enactment. The question is, under the Administrative Appeals Tribunal Act, or the AAT Act of 1975, is there a requirement that for the AAT to have jurisdiction, is there a requirement that the administrative decision must have been based on an enactment? And if there is such a requirement, is it sufficient that because the administrative decision was based on an enactment, therefore the AAT has jurisdiction? Is that enough? Okay, or is there more? So that's what we're going to be looking at as well tonight. Okay, and before I continue, to the tutorial question, let me just remind you as well that in the particular facts, just by way of reminder again, when we speak of judicial review, what we need to remember is that judicial review is not limited to the ADJR Act, okay? There can be judicial review on the basis, as we said, of Section 75(5) of the Australian Commonwealth Constitution, which vests in the High Court an original jurisdiction to issue an injunction, prohibition, or mandamus in relation to officers of the Commonwealth. So we have that. That's a constitutional judicial review vested in the High Court. And we have a similar statutory authorization under Section 39B of the Judiciary Act of 1903, Commonwealth, which vests in the federal court the same power to issue writs of mandamus, prohibition, and injunction against officers of the Commonwealth. So we have therefore a constitutional basis for judicial review, Section 75(5) of the Constitution. We also have a statutory basis for judicial review, either the ADJR Act of 1977 or Section 39B of the Judiciary Act of 1903, Commonwealth. The distinction between the two statutory enactments is that the ADJR Act is broader in the sense that the grounds for review are broader, the review powers of the courts are wider, because in comparison, when you speak of the Section 39B of the Judiciary Act of 1903 Commonwealth as a basis for judicial review, because the remedies are limited to prohibition, mandamus, and injunction, necessarily for these remedies to be available, you need to comply with the certain common law requirements, which therefore narrows the grounds for judicial review, as well as the ability of courts to do certain things. The power of the courts are therefore broader when it comes to the ADGR Act. So your intention would be to go to the ADGR Act when you can. The only problem is that the ADGR Act of 1977, if you will recall, can only be availed of if the administrative decision was based on an enactment. So in other words, if the decision was not based on an enactment because the decision is based on the exercise of a non-statutory executive power, you cannot have recourse under the ADGR Act. So that's just a reminder. And then we also recall that apart from the constitutional judicial review, and we have the statutory judicial review, also the common law judicial review. In other words, long before the Constitution came about in Australia in 1901, and before the enactment of the ADGR Act of 1977 or the judicial review or the Section 39B of the Judicial Act of 1903 Commonwealth, courts in the UK had long exercised their power or asserted their power that they could police the unlawful exercise of executive power. So there is that other source of power. Okay. So having said that, 1, 2, 3, 4, 5, 6. Okay. So having said that, let's proceed to quiz discussion question 1. Can I get a volunteer to read question 1 for us? A volunteer? Just to read the question.
Yeah, I can again, Andrew.
Thank you.
You're talking about discussion question 10 on Moodle.
I think so, yeah.
Yes.
Okay.
The Financial Regulatory Agency, FRA, a federal regulatory agency that regulates the financial advisors industry, ruled that Mr. James Bull did not meet the professional experience required to be admitted as a registered financial advisor under the Financial Regulations Act, Commonwealth. Mr. Bull sought to challenge the decision in an application for review to the Administrative Appeals Tribunal. The FRA objected to the jurisdiction of the AAT on the grounds that the AAT had no power to rule on a matter that involved a legal interpretation of the Financial Regulations Act. Is this objection tenable?
Thank you. Thank you, Millie. Would anyone care to attempt to answer that question? Let me just point out that for the purpose of this particular discussion question, we are assuming that the AAT has jurisdiction. So that's not our focus for now. We're going to look at when the AAT actually has jurisdiction, as I will explain later on. But for the moment, let's just assume that the AAT has jurisdiction. However, that jurisdiction is being questioned because the FRA is asserting that the AAT cannot examine legal questions in relation to administrative decisions. Is that a correct objection?
Manjo, it's Joshua.
Yep, just Joshua. My name is pronounced as Manjo.
Sorry, Manjo.
That's all right. Go on, Josh.
My apologies. So, just in regards to that question, I would have thought no, they would not have had the ability or the power to rule on a matter that involved legal interpretation. If I understand it, the AAT is not exactly made up of judges except for the presidential chair or whatever it is. So they would not have any sort of authority on any legal matters, yet based on their knowledge or skill set within their particular industry, like engineering or mathematics or social sciences or something like that.
Interesting. Okay. Yeah. What did the others think? I mean, we would ordinarily think that, because of the idea of merits review, we would assume that merits has got to do with, the correctness of the facts or the proper exercise of discretion. Because if it is about the law, then it ought to be the courts which should be examining the legality of decisions. However, okay, and this is a crucial point, when you speak of merits, remember, why did the AAT come about? Why was it created by the Commonwealth government in the first place? The reason why the Commonwealth government created the AAT in the first place was that the Commonwealth government felt that if citizens who were aggrieved by administrative decisions could only go to the courts, then that would be a huge disincentive and would clearly discourage a lot of people from seeking a review of decisions, because imagine having to go to the courts. You need a lawyer for that. There's the cost of time, because of the legal process involved. You need familiarity with the laws and the legal processes. There'll be cost, and it's a bit longer. So the government felt that there had to be an agency within the executive that could be informal, less technical, and would be more expeditious in arriving at a decision that reviewed a decision of an administrative decision maker. Now, having said that, if the power of the AAT was limited merely to examining whether there was a finding of fact by an administrative decision maker was correct, if it had been limited to that, and therefore the AAT, for example, could not examine questions about the application of the law, or whether or not the original decision maker properly interpreted the law, would it have to mean, therefore, that you'd have to go to the courts simply because you felt that the original decision maker wrongly interpreted a concept? For example, it could be that somebody seeks certain Centrelink benefits because that person is encountering hardship. Okay, hardship is obviously, as a concept, is a question of fact. Are you experiencing hardship? Do you have money, and so on? But on the other hand, it is also a legal question. What exactly is hardship from the viewpoint of law? And when you speak of hardship as a legal question, it actually means that would be applicable to anyone, regardless of the factual circumstances. We should have an objective standard of what hardship means. Or it could be a question of questions like, did that person freely give his consent? But consent is apart from the question of, I've got a dog who wants to come out. Can you give me a second? I need to let him out. He's been trying to get out. Give me a second. Okay, sorry about that. Dogs don't understand instructions to keep quiet. Okay, so where was I? So questions about, did the person freely give consent? Consent can be objectively verified as a fact, but consent is also a legal concept. So in other words, what it means is that when you look at it from the viewpoint of the original decision maker, not only is the original decision maker trying to examine the factual circumstances of a person before him who's trying to, ask for certain benefits and so on, that original decision maker also has to examine your particular facts on the basis of his or her understanding of the law. So in other words, that decision maker is guided by the law. So in other words, if that original decision maker misinterprets the law, would it have to mean, therefore, that you'd have to go to the courts? And that is the reason why the Commonwealth government actually decided that as far as the AAT is concerned, when you speak of a merits review, the review is not just limited to the factual correctness, a review of the factual correctness of the original decision maker. It actually also involves a determination of whether or not the original decision maker made a decision according to the law. Okay, now that particular legal principle, therefore, is actually espoused in the case of Collector of Customs, New South Wales, versus Brian Lawler Automotive, where the federal court said that when we speak of a decision made by the administrative decision maker, the mere fact alone that somebody objects to the jurisdiction of the AAT because there seems to be a legal question is not sufficient to oust the jurisdiction of the AAT. The AAT, or at least in that particular case, the Collector of Customs, has the duty to actually make a legal interpretation of the law that is given to it. And the fact alone that there is a legal component to the decision will not mean that that person or that administrative decision maker can no longer make a decision. The key point, however, is that while, for example, the AAT will in doing a merits review, also examines the legality of the administrative decision, that determination in relation to the law is not binding because it is not part of the judicial system. So the AAT will make a determination whether or not the original decision was according to the law, but that particular determination by the AAT is not binding. It does not have the same kind of finality as compared to when a court makes a decision. But the mere fact alone that there is a question of law that is involved in a review of an administrative decision will not mean that the AAT does not have a jurisdiction. So in other words, when we speak of a merits review by the AAT, when it makes a merits review, looks both at the facts, it also looks at the law. Then it looks at the policy involved. It also looks at the exercise of discretion. So when we say therefore, because you will commonly hear this in the case, for example, of Drake versus Minister for Immigration and Ethnic Affairs, that there is a duty on the part of the AAT to make a determination on whether or not a correct or preferable decision was made by the original decision maker. When you speak of the word correct decision, that decision is correct according to the facts, according to the law, and according to policy. When you speak of, so in other words, because you're talking of correctness, the idea there is that there is only one correct decision according to the facts, law, or policy. On the other hand, when you talk about merits review and whether or not a decision is the preferable decision, what it means is that there is a possibility that there are potentially many preferable choices, many choices that would be correct according to the exercise of discretion. But there is a question of whether or not a particular decision is the preferable one in the exercise of discretion. So in other words, we will later on know that even when, and we're going to review this in the succeeding weeks, we will then know that even when an executive decision maker is given the discretion to make a decision, let's say according to the best judgment of the decision maker. So in other words, even when the law says the decision maker has absolute discretion according to what he sees fit, even if that is a broad power that seemingly is given to a decision maker, it doesn't mean that it's actually absolute, so that the decision maker can make an outrageous decision which has no foundation for it. It still has to be according to the law. Otherwise, it will be considered unreasonable. If the decision, therefore, if the exercise of discretion is unreasonable, it will be considered unlawful, as we see later on. Okay, so in relation to this particular question, the answer is the objection on the objection that the AAT has no jurisdiction to rule on a matter that involves a legal interpretation. That particular objection is not tenable, because when the AAT undertakes a merit review of an administrative decision, it has the duty to make a determination as to whether a decision is correct or preferable according to the law. And when you speak of the correct decision, remember we examine the correctness of the decision based on the facts, the law, and policy. Questions so far before we continue? Okay, very good. Let's proceed to question 2. So that particular question, I think, provides an answer to quiz 2, right? Because one of the answers here is actually addressed by that particular question. Can I get somebody to read question 2 for us? Can I get a volunteer? Thank you. Josh?
Students protested against the visit of the Chinese Defence Minister to the Australian Parliament in February. When the student protests went out of control, student Josh McArthur suffered injuries after he was shoved to the ground and kicked by a member of the Australian Federal Police. He filed a complaint to the Commissioner of Police against the police officer who caused his injuries. After an investigation, the Commissioner of Police made a finding that the police officer involved in the incident was not at fault and decided against taking any disciplinary action against the police officer. Josh intends to have the decision of the Commissioner of Police reviewed and has come to you for advice. He wants to know if he can file an application for review to the Administrative Appeals Tribunal. What would you tell him?
Thank you. Thank you, Josh. Any volunteers to answer that particular question? Okay, so let's examine the facts here. We don't really know on what basis the Commissioner of Police exercised his power to make a decision. The power being the power to discipline the police officer or not. So, okay, so when the Commissioner of Police made a finding that the police officer involved was not at fault and decided against taking any disciplinary action against the police officer, did the Commissioner of Police make that decision or make that determination on the basis of a statute? Or was it on the basis of a non-statutory executive power, which we already said exists? So we don't know that. So the answer has to be, because the facts don't tell us what is the source of the executive power involved, the answer, will have to be dependent on the conditions we consider. So one, if the decision of the Commissioner of Police was based on the exercise of a non-statutory executive power, because remember we said that the executive has non-statutory executive power either on the basis of the Constitution or the implied powers of the executive. So if we assume that the Commissioner of Police made a decision exercising his non-statutory executive power, automatically it means that the AAT has no jurisdiction. Okay? So we will see later on that the AAT will only have jurisdiction if the exercise of the executive power was based on an enactment. Okay, but that is not enough. The second point is that even assuming that the Commissioner of Police made a decision on the basis of the exercise of a statutory executive power, the second requirement is that that particular statute must also provide expressly that a review of the decision based on that enactment can be made to the AAT. So there is a dual requirement, therefore, in order for the AAT to have jurisdiction over an administrative decision under Section 25(1) of the Administrative Appeals Tribunal Act. One, that the executive decision was based on an enactment, and secondly, that particular enactment must also provide that any decision based on that enactment is also subject to review by the AAT. Okay, so unlike the ADJR Act, where we said, of 1977, where we said that when the executive makes a decision on the basis of an enactment, therefore the ADJR Act is available for the purpose of seeking judicial review. When it comes to the administrative appeals, and remember in that case, therefore, the judicial review is based on the ADJR Act itself. So it is the ADJR Act providing that when an executive decision is made and that decision is based on an enactment, it is the ADJR Act itself which is the source of the power of judicial review. On the other hand, when we speak of the Administrative Appeals Tribunal Act of 1975 Commonwealth, as we said, there are two minimum requirements concerning jurisdiction. The decision must have been made based on an enactment, and the enactment itself must provide that there is recourse to a review by the AAT as provided under that particular enactment itself. So in other words, when it comes to the jurisdiction of the AAT, it is not the Administrative Appeals Tribunal Act of 1975 Commonwealth, which is the source of the power of the AAT to review a particular decision. It is not. It is not the AAT Act of 1975 Commonwealth. It is actually the specific enactment which had been the basis for the exercise of the executive decision. Okay? So, in answer to that particular question, in relation to the question of whether or not he can file an application for review to the Administrative Appeals Tribunal, the answer would be that no. It depends. The AAT there can only be an application for review to the AAT if the decision of the Commissioner of Police was based on an enactment, and the enactment itself provided that an application for review of that particular decision could be made to the AAT. And the jurisprudence for this would be Director General of Social Services versus Hale, which is a decision of the federal court. Questions? Comments? We're good? Okay. So that was, I think, hopefully, you got the important point there. Question 3. Can I get somebody to read question 3 for us? Question 3, just to read the question.
I can do it again if you like.
Thank you, Josh.
Kim Upshot operates a car rental business and has been doing most of the business accounting tasks on her own. An audit by the Australian Taxation Office revealed that Kim had misinterpreted key provisions of the Australian tax laws and as a result was deficient in the payment of taxes in the amount of $4,965. She asked the ATO to review her tax liabilities. The ATO affirmed its decision and reiterated the reasons for her tax liabilities. She was advised by the ATO, however, that the relevant laws allowed her to have the ATO decision reviewed by the Administrative Appeals Tribunal. Kim then sought legal advice to determine the next steps she should take. A tax lawyer was of the view that a proper interpretation of the relevant tax laws and certain factual matters not brought to the attention before the ATO would show that Kim only owed $2,464. At the tribunal, Kim included in this statement of reasons for her application that the ATO interpretation was wrong and that it had failed to consider certain factual matters that would have caused a reduction of her tax liabilities to $2,464. The ATO argued that it was not open to Kim to raise these new matters as they had not been brought before the ATO. It argued further that the tribunal's power of review was limited to the matters and reasons cited in the ATO decision. Who is correct and why?
Okay, thank you, Josh. When you think about it again, you can see the value of administrative law because, this is tax return season for us. And it's possible that the AATO may subject you to an audit. I had a tax audit last year because I was claiming home expenses against my taxes to reduce my tax liability. And they were wondering, how can you claim home expenses if you're working in CQ Uni? And they actually did an audit, but it was a good thing that they upheld. They affirmed that I was actually in a position. I had the right to seek home expenses against my tax liabilities, but assuming that the ATO had made a decision which I wasn't happy with, then I would have had to examine, should I seek an internal review of the decision of the ATO? Should I go to the AAT? Should I go to the courts? So what it suggests, again, to all of us is that the executive constantly makes decisions that affect us. And an example is really the taxes. And it could be that you're running a business and then all of a sudden you get charged by a particular tax liability. And I know for a fact that there have been a lot of instances where people would claim deductions for uniforms. And they thought that, they could, or even for laundry and so on, or even for books and so on. And then, the ATO says, no, you can't do that. Or it could be about, claiming certain exemptions on the basis of mortgage and so on, which I'm not very familiar with. But if you are unhappy with a tax liability determination by the ATO, it is an advantage if we have an idea about administrative law, because then you know what the law might be and what the legal processes are to seek a review of an ATO decision. Okay, anyway, going back to this particular question, what do you think is the correct answer here? Who is correct and why?
If Kim introduces some new information that the ATO was not originally privy to, that would then change basically the information that the ATO made their decision upon. So it would have to go back to the ATO, in my view, because the decision changes based on the facts.
Very good. So it brings us to that question. where are we now? Where are we? Sorry, I'm beginning to forget what the question is. Okay. Okay, so the question for us now is that in the Administrative Appeals Tribunal, was it open to the Administrative Appeals Tribunal to consider factual matters, consider particular reasons that were never brought to the attention of the ATO in the first place? That is the question. So, is the AAT, the Administrative Appeals Tribunal, limited to the evidence that has been submitted before it? Is it limited to the grounds for review that have been stated before it? Or does the Administrative Appeals Tribunal have the power to actually consider evidence that was never considered before or never raised before the original decision maker? That is the question. Because when you think about judicial review, for example, would it be permissible for the courts to look at evidence that was never before the original decision maker? And the answer would be no, because there seems to be a breach of the right to natural justice. The courts would only be able to examine, make a decision on the basis of what is before it. But how about in relation to the Administrative Appeals Tribunal? Is the Administrative Appeals Tribunal limited to the evidence before it, or could it consider evidence that was never introduced?
Manjo, are you talking about the Greenham case?
Go on.
Hey?
Yeah, go on. Go on. What's about this?
I just see in the notes, so in that case, it's just said that they're not limited to considering the material available to or the reasons given by the decision maker.
That is correct. So, thank you, Billy. That is correct. So, one of the main differences, and which makes the Administrative Appeals Tribunal very powerful, is that the AAT is not limited to the evidence before it, not limited to the arguments presented before it. It has the power. It is actually meant to sit in the shoes or step in the shoes of the original decision maker. So in other words, if certain evidence had never been presented before the original decision maker, even if certain evidence had never been considered by the original decision maker, it does not stop the Administrative Appeals Tribunal from going over that particular evidence, because the AAT steps in the shoes of the original decision maker. Yes, Josh?
That would be the de novo hearing that you've written in your notes.
You're right, Josh.
Okay.
Very good. I think that's a better technical term there, because what essentially happens is that in the course of a merits review by the AAT, what actually happens is that it conducts a hearing de novo. So in other words, it's like it's a new hearing. It steps in as the original decision maker. If you look at judicial review, it is not a de novo hearing. The hearing before a judge in a judicial review is limited to what is before it. But in a merits review by the AAT, what it happens is there is a de novo hearing, a new hearing from the beginning. It's a new hearing, and the ATO, the Administrative Appeals Tribunal, actually steps into the shoes of the original decision maker. And that makes it very powerful, because in doing so, because the AAT steps in the shoes of the original decision maker, the AAT is in a position not only to vary or change the decision of the original decision maker, it can even substitute its own decision for that of the original decision maker. Okay, so varying a decision means, you change a little bit of that of the decision, but to substitute a decision means it's a totally new decision. So that's why, it's always preferable to go to the AAT, because the AAT has the power to change an administrative decision or even substitute a decision. Judicial review, on the other hand, is limited. Judges undertaking judicial review cannot vary a decision of the original decision maker, and certainly they cannot substitute their decision. for that of the original decision maker. So in other words, questions about the exercise of discretion, for example, or the exercise of a decision based on a policy, the Administrative Appeals Tribunal can come up with a new exercise of discretion to determine what is the preferable decision in relation to a particular case before it. When you speak of judicial review, on the other hand, it's said that the judicial review is limited because it can only quash a decision, meaning set it aside, but judges undertaking judicial review cannot remake a decision or vary a decision. When it comes to a merits review before the Administrative Appeals Tribunal, on the other hand, the AAT has the power to vary the original decision or even arrive at its own decision, because it can substitute its original decision because of the nature of the powers of the AAT. And we also said that the AAT has does a de novo hearing, which means it steps into the shoes of the original decision maker and is in a position to gather new evidence that was never considered before the original decision maker. So that makes it really different from the limited power of judicial review. Questions? Clear? Very good. So therefore, as much as possible, if you want a review of a decision, you would prefer to go to the AAT, because the powers of the AAT are broader. Oh, the other thing we need to remember as well. Look at advance. Yeah, very good, Harry. So the very, very good point that Harry raised here. So the other advantage is that with the AAT is that the AAT is not bound by the rules of evidence, by the traditional rules of evidence. They're not formalistic, they're not legalistic. And so therefore, when you contrast this with a judicial review process, courts obviously have to follow the rules of evidence. So hearsay, for example, would not be permitted in a judicial review. When you speak of the AAT, therefore, however, because they are not bound by the usual rules of evidence, hearsay evidence is permitted. You know what hearsay is if you had evidence? So you kind of say, who killed John? So, and you would say, oh, it was Mary who killed John. How did you know? Did you see it? No, I heard Jim say that Mary killed John. That is hearsay. You did not have your own, it was not based on your own personal experience that you are able to arrive at you're able to make a factual statement. It is based on hearing somebody else. Because when you speak of evidence, you're only meant to attest or testify to a fact based on your own personal knowledge. So if the knowledge is based on somebody else, that would be hearsay. That's inadmissible. But the AAT is not bound by the usual rules of evidence. So in that particular case, hearsay evidence is permissible before the AAT. Questions about relevance or irrelevance. So when you go to a court, for example, one of the crucial points is the evidence relevant? In other words, does that particular evidence before the court, and we're speaking of judicial review, does that lead towards proving or disproving a certain factual question? Because on the other hand, because the AAT is not bound by the rules of evidence, it can consider irrelevant evidence in order for it to arrive at a decision. So that is again another change, another difference, because the AAT is not bound by the usual rules of evidence. Certain, evidence that would not have been admissible before the courts can be admissible in the AAT. And at the same time, what we need to remember is that the AAT actually has an inquisitorial power. So when you contrast this to the judicial review process, courts cannot, on their own, try to seek information. Courts can't do that. That would be inquisitorial. What instead happens is that it is up to the parties and their lawyers to try to elicit certain facts and bring about evidence. It is not the job of the court to do that. On the other hand, when it comes to the AAT has the power actually to be inquisitorial. It can seek certain evidence of its own initiative. It can even direct the parties to do this or to do that because of its inquisitorial power. that inquisitorial nature of the proceedings in the AAT is foreign in the judicial system. Okay, so that's another difference between the merit review process in the AAT and the judicial review process. Questions so far? Okay, we have a final question, and this goes to evidence. Is it? Okay, there, very good, very good. So and we're trying to discuss further the issue about evidence, because as we said, the AAT is not bound by the rules of evidence. How far does that principle go? So that's the purpose of question 4. Can somebody read question 4 for us? Question 4.
I can read again, Manjo.
Thank you, Millie. Thank you.
Angela Adams, a senior IT manager of the Australian Taxation Office, was fired from her job after being found to have unlawfully accessed confidential and restricted information. In terminating her employment, the ATO investigative committee was of the view that she had in fact unlawfully accessed confidential and restricted information. The committee's decision was based on 1. Hearsay evidence. Angela was overheard by an ATO employee releasing certain ATO information to another person on the phone. And 2. Speculation, going by Adams' flashy lifestyle, which could only be possible if she unlawfully sold ATO information. Adams has come to you, a solicitor for legal advice. She wants to know the likelihood of the AAT overturning the ATO decision if the only evidence against her is based on hearsay and speculation. She recalls that the AAT Act 1975 states that the AAT is not bound by the usual rules of evidence. Assume that the AAT has jurisdiction.
Okay, thank you, Millie. I'm just going to provide the answer here because we're running out of time. So if I were going to be the lawyer, I would advise Adams that it is within the power of the Administrative Appeals Tribunal to accept hearsay evidence, because under the AAT Act of 1975, the AAT is not bound by the usual rules of evidence. However, speculative evidence is another thing. There is still a requirement that a decision cannot be rendered without a basis in evidence having a rational probative force. So while the usual rules of evidence may be relaxed in relation to the AAT, the AAT is still required that any evidence it accepts must have some rational probative value. Speculation, however, is not evidence that has any rational probative force. Can you imagine if you make a decision solely on the basis of speculation or on the basis of mere suspicion? So in this particular case, my advice as a lawyer would be that I would still advise Adams not to apply for a review by the AAT because there was hearsay evidence in the first place that was available, and it was open to the AAT to accept the hearsay evidence to arrive at its decision. On the other hand, the evidence based on speculation would not have been acceptable as evidence. However, because of the fact that there is hearsay evidence that would be acceptable, then I would advise Adams not to apply for review by the AAT. Okay, so it's 1 minute before 7 o'clock. Do you have any questions before we go? Okay, very good. So thanks everyone, and I'm hoping that while your minds are fresh, I would suggest you start answering quiz 2, because it should be very easy enough to answer quiz 2 in light of our tutorial tonight. And so with that, thanks everyone. Thanks Clint. That should be Clinton, Harry, Josh, Millie, Rebecca, and Sari for joining tonight's session. And I look forward to seeing you again next week. Good night. Bye.